But first, everyone expects this to be a close election. And most are expecting that if it looks like Donald Trump has lost, there will almost certainly be massive litigation that will end up in the Supreme Court. And there's also a fear among many on the left that this Supreme Court, which is unquestionably conservative, will blindly rule in his favor. Now, let me tell you my take straight out. I am convinced that Trump is going to declare victory on election night, whether he wins or loses, and am convinced that he will do anything and everything he can to be declared the winner, even if he loses. But I do not believe that this very conservative Supreme Court would allow Trump to steal the election. Now, let's take a step back. There's a new guardrail in place, at least in theory, that seems to have patched up some of the vulnerabilities exposed by the attempts to overturn the 2020 election. In 2022, Congress passed a bipartisan bill called the Electoral Count Reform Act. That law made some significant changes to how state elections are certified, how challenges are decided, how objections are lodged in Congress. Among the key provisions, the new act increases the threshold for members of Congress to challenge a state's electors. It now requires a fifth of both the House and the Senate to be on board before an objection is recognized. Previously, it's needed a single member of both chambers. It requires governors to submit each state's slate of electors, meaning rogue state officials can't submit an alternate slate, a scheme that was attempted in Wisconsin and Georgia and elsewhere in 2020. Only the governor's slate is considered official. And the law also streamlines the process for challenges and fast-tracks them, moving cases directly to federal three-judge panels and then right to the Supreme Court. But one risk becomes, well, what happens if Donald Trump and House Speaker Mike Johnson decide they don't think the new law is constitutional? And what if they try to force a state that Harris won to delay appointing its electors past the December 11th deadline? It's a separate deadline that wasn't talked about as much last year. Speculation ran rampant after Trump, during his rally in New York on Sunday, made a coy reference to a little secret he shares with the speaker.
I think with our little secret, we're going to do really well with the House, right? Our little secret is having a big impact. He and I have a secret. We'll tell you what it is when the race is over.
During a speech in Pennsylvania the next day, Johnson denied there was anything nefarious going on.
It's not scandalous, but we're having a ball with this today. The media, their heads are exploding. What is the secret? It's this thing we have about, it's a get out the vote. It's one of our tactics on get out the vote. But they're convinced, like, we've got this, like...
A prominent liberal legal journalist, Elie Mystal, is out with a new article in The Nation arguing that, quote, the secret almost certainly involves a plan to install Trump in the White House if he loses the election. Now, whether or not this little secret is actually part of a big plot to steal the election, it seems clear the Supreme Court will be called on for some key rulings if Trump loses. And no, I don't think they will allow for what would effectively be a coup. Yes, the court's presidential immunity ruling was very pro-Trump. And even this week, the High Court granted an emergency appeal from Virginia's Republican Governor Glenn Youngkin, which allowed the state to purge more than 1,600 names from its voter rolls of people the state identified as non-citizens, overruling a lower court judge who deemed Youngkin's move illegal, finding that some fully legal citizens appeared to have been caught up in the state's purge. No question, that is a big, let's call it pro-right ruling by the court. But what about when the court rejected an emergency appeal from Robert F. Kennedy Jr. to get his name removed from the ballot in two battleground states where his presence is likely to hurt Trump? Only one justice, Neil Gorsuch, dissented, and only in the Michigan ruling, not Wisconsin. That ruling is a blow to the Trump campaign in the two states where a few thousand votes for RFK could swing the race. And what about when the justices denied Green Party candidate Jill Stein's push to be restored on the Nevada presidential ballot? Stein was tossed after the Green Party failed to submit a sworn statement vouching for the authenticity of the signatures it collected to get her on the ballot. Unquestionably, her presence on the ballot would hurt Kamala Harris. And perhaps that's why, by the way, Jay Sekulow, a former attorney for Donald Trump, represented the Green Party and brought the case to the high court. The justices threw out the case. Stein will not appear on the ballot. Another blow to Trump, courtesy of this court. Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.